Hi, my name is John Guttmacher. I'm the author of the Florida Firearms book, with over 230,000 copies sold, now in its 25th year and 9th edition. I'm a criminal trial attorney and NRA certified firearms instructor with over 200 jury trials as both a prosecutor, criminal defense attorney, and civil trial attorney. I'm considered the leading legal authority in Florida on legal issues dealing with firearms, weapons, and self-defense. Now we're going to go over a few very important legal areas of Florida law, primarily self-defense. However, in my opinion, a full presentation on the law of self-defense would take at least 4 hours to cover. That's just one reason I urge you to consider purchasing a copy of my book, Florida Firearms. It covers virtually every question you might have regarding firearms, weapons, and self-defense laws, except hunting. So let's start with the basics. As a general rule, to use self-defense of any type in Florida, you must have a reasonable belief that you are facing imminent physical harm, and the amount of force you use or threaten to use must be commensurate with the threat or degree of force you are facing. Florida treats the use of deadly force very differently from the use of non-deadly force. In order to use or even threaten the use of deadly force, you must first have a reasonable fear of imminent death or great bodily harm, or you must reasonably believe that your use or threat of using deadly force is both reasonable and necessary to stop or prevent a forcible felony. Now, forcible felonies are the more serious crimes in Florida, such as homicide, rape, robbery, kidnapping, aggravated assault, aggravated battery, or burglary. Great bodily harm involves only serious injuries, permanent disfigurement, or broken bones. If all you might face is a black eye or bloody nose, it is not great bodily harm. An assault is an unlawful, intentional, believable, imminent threat to do physical harm to another person. An aggravated assault, or an aggravated battery, means a deadly weapon was used by the attacker in the assault or battery. Imminent means immediate, not an hour from now or 10 minutes from now, but such that it cannot be avoided in a reasonable period. Okay, let me shoot you a warning here. If a culprit or attacker is trying to escape without trying to harm you in the process, it is rare that a deadly weapon can be used against them. Let me also say that although retreat is usually not required in Florida, there are so many exceptions to this rule that it is normally always better to retreat if you can do so in reasonable safety, except within the confines of your own home. And yes, you do have better legal protections within your own home. The law says that if an individual illegally uses force to enter or uses force to try to enter your home, and they are not a police officer or other person having a legal right to enter, you are presumed to have a reasonable fear of imminent death or great bodily harm, and at that point have an absolute right to use deadly force against them. There are two exceptions to this. First, if you were involved in criminal activity at the time, such as smoking a joint or dealing drugs. Or secondly, where the other person has an equal right to be within the home, or such a person is a grandparent and is trying to take a grandchild out of the home. In either of these circumstances, you must first either retreat before using deadly force, if it is reasonable to believe you can retreat with safety. Now, outside of your home, there are no presumptions to protect you. However, you still have a legal right to use or threaten to use self-defense without retreating, and you can stand your ground where you have a reasonable belief that such is necessary to prevent the imminent commission of any violence upon your person or another person. However, if you are in the commission of criminal conduct at the time, or are at a place you do not have a right to be, you must first retreat before using or even threatening to use force. Of course, the threat or amount of force you use must be commensurate with the threat you face. You cannot use or threaten to use deadly force unless you first have a reasonable fear of imminent death or great bodily harm, or where such is reasonable and necessary to stop or prevent the imminent commission of a forcible felony. One last word about the book. All of the situations I've touched on, and hundreds more, are fully explained in the book, both legally and from a practical how to handle it standpoint. If the book only saves you from one situation, it's paid for itself 1,000 times over. And I guarantee you that sooner or later, that one situation will come up. Not necessarily in self-defense, but in the hundreds of other legal situations my book discusses and explains. If you think paying $35 isn't worth spending a night in jail, going to prison, or losing your Second Amendment rights, then pass it by. But if you want to do the smart thing, join the 230,000 others who have bought the book and thereby stayed out of trouble, or at least knew what to do when it hit. I'm John Guttmacher, author of the Florida Firearms book. Thanks for listening, and stay safe.